the state will, based on what information they gather from their investigation, they'll make a finding. And from that, then we'll know where.
All right, thank you for clearing that up. Yes,
An
ma'am.
investigation by the Secretary of State, is that correct?
When there's an ethics board, and that, yes, ma'am.
Okay.
We had a complaint from the citizens group about how our industrial board is comprised. And after speaking with our attorney, the industrial authority cannot elect any individual to sit on the board. I'm gonna read what he wrote, if you don't mind, Nick.
Oh, that's fine.
Can you read also the complaint of what exactly the
I think maybe I can, I don't know, it's, well, let me, I think it'll explain itself.
okay, all right.
Because I had the same question you did. I thought, well, this complaint, but actually the complaint is factual in law, Georgia state law. And so this is how our industrial board needs to be corrected, and then from January on, and maybe the mayor and the county commissioner can say, we did this part. But here's his response. We nominate 3 at large because you have a county commissioner, he elects 1 elected official, and then he elects 1 at large, and they vote on it. Then the mayor elects 1 elected official, and then 1 at large. So that's 6. Well, we've got 3. In the past, we had to beg people to come on the industrial authority because we could never get a quorum, never. Bankers wouldn't come, anybody that we put on there wouldn't come. So we've got 3 people that I don't remember. I talked with Carl if the county did it, but we had Rodney that we nominated. We had, I had it written down, Rodney, Kendall, and Randy are the 3 that were nominated by the IA, and I guess we voted on it from the IA, Industrial Authority. Do you remember ever bringing those individuals before a vote to the council?
No.
And Carl didn't either.
Let me say this. I was asked, I was questioned, and my genuine answer is, and I'll say this before everybody, when I got elected, so much happened. So much was coming at me, and so there were so many boards that I had no idea that were even in existence. And
I'm right there with you, bro.
and I wish I could, but I'm not embarrassed to say that I cannot remember.
That's fine.
I just can't remember.
And what the law says is the city mayor appoints 1 other elected council member and 1 unelected, and the county commissioner appoints 1 county, 1 elected official, and 1 unelected. So what I would like the industrial authority to do would be to nominate the 3 people we have, Kendall, Randy, and Rodney, and present it to the county commission and to the mayor. And both councils, from what I understand, have to approve. If the mayor, they don't approve it, then we have to start all back over again. And I guess we could submit the same names again. And I don't know how the process goes.
Well, to my recollection, when I was approached about serving on the industrial authority, was that it had to be approved by both county and city. That was my impression, that I had to be voted on to even be allowed on this board.
Do you remember?
I didn't attend either meetings, but I do remember being told that was supposed to be a process. Now, whether it did or didn't happen, I don't know, because I didn't attend those.
And I'll take responsibility on that because I did not know.
And to your defense, Walter, so in the neighbor legislation, it does say the elected, me and the mayor, upon our term, we make appointments. You can take that as yearly or through the term. And I think the at-large membership is when they're appointed, you just think they kind of served for the board itself. And there's really, I've never seen anything that says they have a term, But the way it says in the neighborhood legislation can be a little bit confusing, so,
Well, Nick had responded, and he says that's the law.
okay.
All in the past, and I've been on the board probably 3 or 4 years, we've never done that I know of. I think it was because we were so desperate to try to find people to sit on the board. And that's where we are today. Let's correct it. And then going forward, this coming January, December, whoever's sitting in what spot can make sure that we follow the procedure. Yes, it'd be great for you to step in.
And to the point that was made, it's not uncommon in some of this legislation, local legislation, not to have a term set. And ours, with respect to the appointments that come from the members that are the elected officials that county and city, they have terms that are set by, of course, their office, and therefore that drives some of that evaluation. For these three at-large, as I recall, you don't have a term, but even in instances where you have boards that have been placed and seated and there are terms and people extend beyond their term, they continue under the law, it considers them to be properly there until such time as the steps are taken. Because some, they're just, we have a lapse, but the process results in there being gaps in these things being seen about. So, what recommendation I think I would make is, because of the absence of that, to consider what you've recommended is certainly appropriate, but what to consider is go ahead and set up, you can set, we want to make these appointments every year, make that part of your policy for these three, and do that on an annual basis, and adopt that, because it doesn't set that annually in that, does it?
I think it is.
Is it annually in there?
3 at large.
Or every year?
I think we had that conversation, when we transitioned Scott. I think that was
Do it
part
every
of
year.
some of the conversation then.
So we would have the recommendations from the IA every year,
For those three?
Right.
Yes, sir.
or for whoever the industrial authority wanted to they can't appoint, but they can nominate.
Yes, sir.
Nominate.
That's
Okay.
correct. Then, I mean, you just have a process, and you would say that would be your first order of business, either in January, December,
Right.
probably, and then ideally, however you choose to make that fall, you would have those members up and going January, February.
Okay.
Walker,
Yes.
if I can remember correctly, everyone that's been needed a vote who was sick. Mr. Mayor, you called it out, we voted. I don't remember his name called.
Okay. I
It's not,
you may be correct, Councilman Moses, but I knew that I could so much happen. I couldn't remember. Yeah.
With that,
But thank you.
Library board and the.
Okay.
So something to consider on that, I guess, would be, making preparation probably around November, because it's gotta pass the boards before it comes to
It should.
vote, in January, or in effective January, so.
Correct. I agree.
So what's the will of the industrial authority? We want to go as we are? Do we want to resubmit the names to the different county commission and to the city? Mr. Moses said that it had been done. I don't know if we need to wait till the next meeting to.
And that's just me. I think we should, especially if there's a member who can remember that process has been done. So what I will do concerning the city is I will go back. Our clerk and I will go back and search our records to just see if we're correct on that.
So what you're saying right now, technically, we're not in compliance with state law, technically.
We don't know.
No, that's not.
I'd just refer that to the attorney. Are we in compliance currently?
Well, we don't know how, whether they're voting or not, or approval or not has occurred, so.
Well,
so we can't
I
say.
guess you'd have to table it till you can determine that. Cause if we were in compliance. then
Well,
of course
if we table it and we come back and find that it hadn't been done,
then I think.
then we gotta do it again. So my personal opinion is, doesn't influence anybody, but I think if we just submit the three names, let them vote the next meeting, we won't have a meeting for then anyway, and let them vote, I don't foresee any problem with any of the three. In
Uh,
fact, I would be very disappointed with the county and the city if they did not appoint the three that's been sitting
That
all
way
year.
you ain't killing
I
time.
think we done started out this year, stayed with what we got.
Right.
And
And then we'll go
Walter
in
just
November or whatever to redo it.
Send me the email and I'll put it on the agenda for next month, July meeting.
Do we need a motion for that?
I don't know, Ms. Phillips, that's a good question.
I said, that's a good
I
question.
would think so.
Yeah.
Okay, to put it on record?
Yes.
All right, I've got a motion from Ms. Phillips to send the three candidates that, or the three existing members on the, IA board to the county and to the city for an affirmative vote,
Right.
hopefully. Because if you disagree, or if the mayor disagrees, or anybody, and they don't approve it, then we've gotta start the process over again.
And going forward, every, I guess in November, and of course that aligns with an election from the city, or the county, that if there was a change in hands, then that new person would then appoint people that they wanted to start in January.
But it was annually, correct? So that
Yes.
means-
Yes, every year.
And I'll-
Yeah, but that's what I'm
But in
saying.
those, in those election years, that would be
Yes.
accurate,
Right.
yes.
And I'll write down a process, because that's one of the problems, like I say, up till the last 2 years, I guess, you couldn't get anybody to sit on here. And so that's why they expanded it now, so we could get a quorum. But anyway, let's set the process. I'll send you and you, the recommendation from the IA unless I hear something different. And then we'll write down a process and I'll bring it to maybe the, September meeting or something.
So you have been sitting on this board all along?
Pardon?
You've been sitting on?
I was nominated by the, county and they voted on me.
Okay,
Yeah, I've been sitting on the board for
Right.
at least 4 or 5 years.
okay. And
But
they,
as at a large sometimes and as a appointed, so.
and you couldn't, and the authority couldn't get people to show up?
No, I mean, even bankers, I mean, we had bankers, and the table was one table, and it was very, we never had this, nobody could come up and be concerned, even though we were spending their tax dollars.
Mm.
It's important.
Thank y'all for being concerned.
Yeah, I agree, that's why I think it's important for them to have comments.
So do we need a motion?
She made a motion, we need a second. Did you get that any kind of way?
I've got the second is Carl, right?
Okay.
Motion.
Yes.
Motion.
I got Karen.
I will try to get, do I hear any opposed? I will try to get you those names, mayor and county commissioner, this week, okay? Okay. Those were really the only two things that I had that was, I got attorneys for August meeting. If we would want to discuss any particular thing. We're at community comment unless the industrial authority members have anything else they wanna bring up.
Well, Walter, I think the mayor relaxed the agenda.
Yes.
Did you?
Yes,
I'm sorry, I didn't mean.
No, you did. I had it on 11, but he did it right after the, agenda
We
approval.
did, I'm sorry.
No, okay.
Um,
It was voted on.
I am, my purpose for relaxing the agenda, I want to get, a clarity on, the other day when, you and I and Susan were speaking, conversing through, either text or email, about, it's really about the attorney interest.
Attorney what?
Interest, we were.
Oh.
Yes, and I was just trying, and I think they're both here, that you are Nick?
Yes.
Okay, all right, and Mr. Rowell is here. And, I was just genuinely concerned about, what you can communicate with me, Mr. Hudson, about, maybe them not just really getting back with you or being open or, conversing or responding. Are we better with that? And since you were here, I would like for y'all to speak. And I'm just wondering, because I know we voted, and you're a part of this, and it's the people are here to support. We're on this, we serve on this board, but the people have the right to hear and to know. And I just kind of.
We addressed this at the last meeting, and, Mr. Darcy.
Rose.
He explained, because there was some concern about, the, Tony reviewing the next era, was it, you know, an ethics thing or whatever, and Mr. Dorsey explained that he didn't see any, and we voted that Nick and Tony would, or their firm would represent the industrial authority. Nick has been very forthcoming with any information that I asked for. I have not received any emails from any of the industrial authorities, people, board members, that requested a clarification on any attorney questions. So, and I've got a couple of, one of the main ones that we've been back and forth on is the ethics complaint. And Nick looked up the law, looked up our bylaws, and he gave his opinion. So I don't understand. I mean, they've been, since the last meeting, they've been very forthcoming with any information that I've asked for.
Oh, okay, so now since Friday, they've been forthcoming.
No, since last meeting, they've been.
Okay, all right, so well,
Because we affirmed that they were our attorneys.
okay, well, I gathered from the message that we shared on Friday that maybe Nick wasn't really involved or making a real attempt to
The only.
reach out.
The only thing was I invited Nick back in April 18th, which was well before last meeting, to come to the May meeting to help discuss some issues that, about the bond resolution. He had some issues to come up. If you remember that text I sent you, said that he had some issues to come up. He didn't come. They, nor the attorneys, have requested to come before the industrial authority to answer any bond resolutions. But that's really questions. That's not really their job. Our job is to submit questions to the attorneys, then they respond. And as far as I know, nobody on the industrial authority, not to me, has asked or requested any questions to be asked to the bond resolution.
Okay,
Have you hadn't sent anything, have you, Mayor?
no, I have not.
And may I say something?
Yes,
It
please.
involves us.
Yeah, that's right, please.
So, different organizations, different chairpersons engage attorneys differently. Some folks, and a lot of it has to do with the size and complexity and volume of issues in business that a certain organization may have. Generally speaking, thus far, the defined relationship has been as Walter has described. You know, he's addressed questions to us and we've responded to those questions. The engagement how our relationship with the board may be defined is determined by the board at large. If the board seeks or wanted us to have, you know, more proactive involvement, that's something we can do. Proactive involvement costs money, right? And you have to consider that. Also, there's a real delicate balance that attorneys and their board clients have to reach, where the attorney remains the attorney and the attorney does not try to be sitting at that table right there and become a member. And so as we are learning to work together, we're trying, on our side, we're trying to understand exactly where those boundaries are and where and how that, you know, through your chairman, the board wants to communicate with us. But, you know, and so we try to respond as timely as we could to the questions that Walter's had.
Without overreach, I suppose, was that a specific case that, I mean, you were talking about the bond resolution and the response that they gave to that, was that the specific conversation
Well,
that you were
the
all having?
ethics question for the individual.
The concern of.
Yeah, and the bond resolution, you know, it's up for the industrial authority basically to sign off on it and say that, you know, we understand it, we've read it, we don't have any questions, and we pass it on to the district attorney. Once the district attorney receives it, then he's gonna present it to a judge, which I understand it's in Worth County now, they've moved it out of the district. Once the judge signs off on it, it's incontestable. Now, and the reason it says it in the state law, Tony, please jump in anytime
You're cracking.
but it's incontestable. So there is no being able to beat it anymore, or whatever you wanna do, or change it. Let's use the word change. So, the monkey facility, they just got turned down by the judge, basically, because it's state law, it's incontestable once the judge signs it. So this is why it's so important for the industrial authority to have read the bond resolution, understand the basics. I know, Rodney one time said, well, you just gotta trust the lawyers. Divorce decrees, you better read everything it says, you know, or any type of business reaction. So that's what I have implored upon to get industrial authority education, which you have, Carl has, several other people have, and to read the bond resolution that we're getting ready to pass on to the district attorney. And then once the district attorney gets it, he's just gonna say, well, you know.
They said it,
There you go. And then when the judge gets it, how's the judge going, unless somebody has some type of standing or something, can say, well, this is why, judge, you don't need to sign it. I know they use the wording, the divisiveness and the polarization outweighs any economic advantages. And that went over with the judge about like, land tied to a duck.
Yeah.
So, with that said, we can, hear from anybody that'd like to speak, and then we'll go to public comment.
So that's, you're waiting to send it on to the judge for anyone of this board to contest any part of it?
No, we need to do any type of a discussion or talking now, because once the industrial authority signs off on it, then it goes to district attorney.
And he's not representing it, he's just.
He's just presenting it, he's just saying.
So there's a process.
It's just a process. There is no back and forth. This is only really back and forth.
Yeah.
Tony, if I've got the process correct?
That's correct. The district attorney's job is not an advocacy position.
Right.
There's, he serves as a, in essence, you have to have a mechanism to get it before the court based on the way the law's set up, and he has been identified in the statute as the person who's responsible for that, as opposed to you hiring a lawyer and you advancing it, it gets advanced through the district attorney. Then there is an evaluation of that in the court, and the hearing would be here. It would, you know, although you remarked about it, you do have, if you have the judge, you do have a new judge in the 10th Judicial Circuit, and Mr. Powell is from Worth County, but you know, like the others, they handle cases throughout, so I expect your bond validation to be here. And so Walter's correct, and the question is, because there is an outside date at the end of sometimes you guys are from Xterra, and the deadline y'all looking for is mid the 15th or 16th. 17th. And so the question is, the paperwork has to be advanced from the board here to the district attorney, and then the district attorney has to take the steps to do what they're going to do. So that would be the point of discussion.
So did that answer your question?
No, yes, it did, but it just seems to me that it should happen since we've not had that from, this board. That we've reviewed it and we'd like to move it forward, or, I don't know, that's mine.
So what's the next step then? Like,
The next step is to sign off on the document. Well, the next step is for everybody on the industrial board to read the bond resolution. That would be the next step.
so you're the next step to sign?
Well, myself or you, that's what state law says. This 2-page notice of intent to issue bonds and request for filing of validation proceedings in the Superior Court of Irwin County. It seems, and I'm not being disparaging towards anybody, that I'm the only one that has questions, and maybe I'm the holdup, and maybe I need to step aside and let the mayor sign the document. I just got questions because once this and I want y'all to understand what I'm saying, and I know you do, once this is signatures on this document, it goes to the district attorney. And the district attorney is just a conduit. He's gonna pass it to the judge. It's incontestable if the judge signs it. So if you say, well, wait a minute, I wanted to ask a question about that bond. You know, I don't think it, you know, in the MOU, it said, they had a hold harmless to Irwin and Ocilla at 1.6.5, but I don't see it in the bond resolution. Is that a, you know, it's too late to ask those questions. So that's why we need to have discussions, because it's a serious matter. I mean, you're in debt, are we indebting the county for $500 million? What's the bond rating of Irwin County and the city after this is signed? I mean, can anybody on the board answer those questions?
Well, my question, Walter, is I read the language, but it's missing numbers. There should be numbers in there saying what the county, Board of Education and taxation, what would those prorated numbers look like? We had not seen, I've not seen nothing. I looked at the MOU, it's nothing in there. It is a lump sum, but that needs to be broken down. And first, I think it's been unfair to the county when the Board of the Tax Assessors were not involved with the pilot or the 40% tax abatement. Cause that's the burden of the taxpayers. You can take 40%, you're gonna put it in the other glass. Gonna increase that glass, that burden's gonna be in the left hand, you're gonna lose it here. I just think the due diligence on the numbers need to be pursued, and make sure it's fair to the county.
And in Exhibit A on the bond, I know everybody's read it, and on Exhibit A on bond resolution, it says, it's present. It's got Exhibit A in there. But it doesn't have B, C, D, E, and F, because it says it's attached documents, but it's not in the bond resolution. Where are they? Or when are we gonna get them? Or when will we see them? Are we just gonna vote because it's in there? I hadn't seen a completed bond resolution that I received that had those things in there. And go to Carl, there's a repayment schedule. Have we seen a repayment schedule, how it's going, who's gonna handle the, are we gonna be responsible for the?
Payment in lieu of taxes.
Pardon?
It's a payment in lieu of taxes that's set. Well, you can have next year to explain the details of it, but again, I think that we have been for the last 6 months looking and working on this project, and it was duly voted by this board to move it forward. So, I'm just, I understand that we have changes in the leadership at the county, but I do know the repercussions for the average taxpayer going forward without this being done. And, you know, that's my concern. And of course, we have the attorneys on both sides that are reviewing.
And when you say-
in our interest, as clarifying before, that they are working on our behalf with Nexera so that we don't even pay for those attorneys. So that's, and you know, they're still here to put those things forward. So,
When you say, when you mention repercussions, you know, I think it's healthy that we're looking at it at all angles. I do understand and hear you, but I'm just as concerned about the repercussions of what it could mean legally. You know, unless I'm just wrong, we could possibly do something here to put us in a real bad position, like lawsuits and all. I just want to make sure that we do the right thing for all people. And I think it's major, or maybe I haven't heard a strong sensitivity of how we could like default on this or just be sued. And I'm concerned about that.
Are you concerned that the next era would sue? Or are you concerned that the citizens would sue? Or who are the suits from?
It could come from any area, but particularly next era. I feel like we are obligated to do something. That this is an authority that we said that we would do?
I think Tony could probably answer this. The MOU is not a contract, and they used
Well, he's
MOU to
the-
come up with the bond
He's
resolution.
the attorney,
Now,
so-
once the bond resolution is signed by the judge, it is a contract.
Right.
Is it a contract currently?
I believe it is, yes,
So have we already entered into the contract?
yes.
So there's no change in the contract?
The basic terms of the contract are fixed.
Pardon?
The basic terms of the contract are fixed to the extent that, and I'd have to go look
But
at the
we
bond
said-
documents, that
That's
the
what I'm
absence, the absence of those exhibits that you described, I need to look and see what that is. Because, you know, that's after the MOU, we're talking about the next phase of that set of documents. I need to be sure that, what that's about. But I need to answer that question. I can't do it without reviewing that final set.
Well, it's my understanding the MOU was gonna be incorporated into the bond resolution, but it seemed like they left out a lot of, not a lot, but some items that would be important to Ocilla-Irwin County.
But we need to look at that, because the two things that I recall that should have been in there was, you know, the indemnity provision and the venue and, jurisdiction issues that we talked about, because, to the extent there are issues, we don't wanna be in Atlanta or Delaware or anywhere else, you know, if we do end up in court. And the draft, I thought that information had passed through, is what I believe to be the case, but I have to review the documents to be sure.
So can it be amended? I know you said no changes, but can anything be amended?
Well, the validation process, that to the extent that there's additional information to round out that set of documents that goes to the court, that's not gonna change your core terms of your agreement, but that, you know, that's more of a dot your I and cross T's, just so that you advance the full set and proper set of documentation through the district attorney to the court. But, you know, you know, right now, if you know, let's assume that I'm correct, that we do have an agreement, then, you know, if you ask these folks here, can we change this right now today? If they have the authority to do it, you may be able to, but otherwise, we have our terms. And so, what's left is to the extent that we have some, you know, I'll just put it on me, sloppy paperwork on this bond resolution, we're not reviewing those exhibits, and we're not getting that to Walter the full set, then I apologize, but that's something I need to look at.
Could those exhibits include the in lieu of tax formula?
The in lieu of taxes should have been part of the MOUs, that schedule, right?
Did you
Yeah.
see it?
I never saw, I saw a blank one, but I never saw.
I've seen a blank one, but I've not seen one.
And when you
with
say
a number.
blank, what do you mean?
Just lines, you can see it in the MOUs, just blank, nothing filled out. And it looks like that's where that goes.
The original one that they promoted, it was a proposed, I've never seen that attached into the MOU. So could you say what you just said, and Walter had some understandability?
Here's what I believe. I believe that the board has responsibility, you know, and look, I understand this is not fully embraced by everybody in the community. But to your point, you have a valid vote to advance it, we agree to and execute the MOU. And I believe that we have an obligation to do that. I think that to the extent that a decision were made where we're just not gonna advance the paperwork, I believe, to your point, that could create issues. And I'm not gonna put words in these people's mouths, but, and so, you know, if I'm at my desk and get a random call from somebody I don't know anything about this, and it's Mr. Hudson, he says, you know, is it incumbent upon us to move forward with this? And the answer would be yes. Yeah, it's hard to say that, because I know how the people feel, I know where we are on this,
Yeah,
but this is what we have.
well, it's a little concerning to me, you know, because as Ms. Phillips stated a while ago, you know, the board and the members have changed since, you know, y'all voted to do this. So when you say, you know, moving forward, what the board voted on, you really can't say that, because some of us might not, you know, agree with. But, you know, I mean, we're kind of, a couple of us are kind of in a catch-22, because, you know, if y'all agree to go forward with the signatures on it.
But it's already been
I understand that.
approved and voted
Yeah.
and approved.
But, you know, then to to your point, the Industrial Development Authority, you know, if we get caught up in a lawsuit from citizens or something, you know, we're right in there, you know, with that, and not having no say-so either way is what I'm trying to say, so.
Well, and the industrial board does not have to vote on signing.
No, cause it's already, it's done.
The only thing that they have to do is they have to have that 2-page, notice of intent for either myself or the mayor to sign, and then the secretary would have to seal it. Is that not correct?
That is correct.
So, but the reason I opened it up for all the board members, because I just think it's a serious matter. If they sue, because they say, well, we had a contract, here it is, then at some point, they may come to the table, because they even in the agreement, they've gotta come to Irwin County. And picking a jury when Irwin County would be, don't wanna coin up 50-50. Would you not disagree with that, Tony?
It is home.
It is home. And you got, just about as many people for as just as many people against. And then Irwin County would be broken by a huge company by, you know, dragging it out in court. But I don't think our local judges would let it drag out too long, but I guess they could appeal it on. So anyway, all that said, I'm not gonna sign, you can not like it, whatever. I don't think it's for right not to have the questions that I have went through the bond and looked at, that was agreed upon, that the MOU was gonna incorporate those into the bond. So I'm out of the discussion as far as that goes. And now, if some point they would like to come up and have a discussion, and show me on the bond resolution where those are and so forth, and get me to where I feel I'm comfortable for signing for it, I will sign for it. I'm not against it, I just don't want to obligate Irwin County for 30 years on something that's gonna be detrimental to the population that I've lived here all my life.
But you're assuming that not getting it will not be detrimental to us. And
It
that's
could,
your-
it very well could,
Okay,
you're exactly right.
Okay.
I don't
And you
disagree
say
with that.
The county, well, and you can always go into what would happen if you sue, and that's everybody's right.
And see, the city doesn't even get any money out of this. It only goes to the county and industrial
Not
authority.
one.
Not one dime.
That is correct.
And-
That is correct.
Yes, but the other thing is it goes to the citizens and the benefits
Yeah.
that go to the citizens.
Well,
I'm
Ms. Karen, the only
I live
problem
in this
is
city,
there's no
but I live in
numbers.
the county.
There's no numbers to validate what you're saying, and no numbers to validate what we're saying. We need to see the numbers. Cause none of us know.
Well,
And is
from
it,
the last, well, I haven't been on the board that long, but from that process, going through that and vetting it and negotiating with this company and working with our attorneys to be in our best interest, even though they were paid by Nextera, those things were put forth in good conscience and looking out for the city. And I just know, Mayor, we are under the process, people are walking around my house reassessing it recently. So we know what that's gonna mean. And, without going forward to this, we lose the possibility of getting that payment in lieu of taxes that will maybe keep my property values, keep the taxes that I pay, which are higher here than they are per unit than in other places.
Compared
because
to what?
Compared to, other properties that I hold. Because the other places have industries and businesses that pay taxes that lower the taxes for the residents.
Well, there's an equation you look at, Irwin County at 28.1, we below the minimum, way below, we're supposed to be around 39 to 40%.
Okay, all right.
So we're low, we haven't had a tax increase in this county since 2007. Some have got one, but we've been running the county budget based on that. But when you're looking at taxation from a development side,
Yes.
you looking at, we haven't seen the numbers. That's the
Okay.
problem. I like to see the numbers so we can let our tax assessment board review that and say it's a good deal. That's what every other county does. When the development authority enters into a pilot program in lieu of taxes, there's some due diligence involved with the numbers. So they're looking at the payoff of this versus losing this. Any way you look at it, 40%, and we're gonna use that as a number, that's 40%. And two, now it did say, and I may be corrected, the taxation is gonna be based off 10 years previous on ag. So, as you know, property values are going up. If you take that 10-year average, that's what, next year would pay what, for 30 years, the average for the 10 years, is that correct?
Am I okay to speak?
Yeah, welcome, I might be incorrect on that.
This is set up so that for every year for the first 15 years, next year will either pay, depending on the amount of bonds issued, they will either pay $2.16 million or 3.28. So if they issue more bonds, they'll pay that greater amount. If they issue lower bonds, they'll pay the lower amount. But for 15 years, every year dies.
But that would be the bond amount, right? That would be what's paid on the bond.
No, that is the pilot payment. There are no payments
So-
associated with the bond. The
So
bond
that's
is
separate.
not a true financing source. And I think I've noticed that there's a lot of confusion about that, which is extremely fair. But I do want y'all to realize that this is not a financing source. NextEra will not be getting $430 million when the bond is issued. There will not be a deposit. There is no sale of this bond on the open market that results in cash. The bond is issued as consideration for the project and for the transfer of the property to the development authority. So it is not financing. It is not backed by the county, the city, the industrial development authority. There is no bond rating. There's no bond rating needed. I mean, it is not a financing source.
And the reason the bond process occurs is you have a legal, it is allowed within the law, but allows for the transfer of the property into the name of the development authority, and that, because that is, the development authority is a governmental entity, then that allows for the abatements for the taxes. So that's the mechanism set up by the statute, one of several, and that's the one that has been proposed, ever been utilized in this.
Well, couldn't that have been put in the MOU, just kind of what you just said,
I know.
because that's the numbers it's missing.
So it is there. It's in Schedule 3.2, but it's possible that one of the versions you had didn't quite have those numbers in it yet. But in the adopted and ratified version, it's there, and it's
What was
also
that,
attached.
what was that location you said?
It is Schedule 3.2 of the MOU, which
3.2, basis for saving?
it's the schedule attached at the end. It's Schedule 3.2.
Schedule 3.2?
Yep.
Year 1 through 115, 2.116 through 30 is 0.
Yes.
So after the first 15, there's no more money?
They, and Kelsey might be able to speak to this more, but the way I understand it is that was negotiated to do like a lump sum on the front end where the value of the property is higher, and then when the value of the property is near nothing, they would be paying $0.
Is that the meal for the lower bond?
So, if I'm able to
Go-
speak as well,
Councilor.
so the 2.16 for the lower bond and the 3.28 for the higher bond, that was negotiated by the industrial authority to pay in the first 15 years. So you get a larger amount of money in the nearer term for time value of money purposes, as you all are really trying to launch the economic development of this community, rather than paying a smaller amount over the full 30 years. The industrial authority also negotiated, typically we pay 1/8 of 1% of the total bond amount. This authority negotiated 3 times that fee. So for the lower bond amount, the industrial authority is gonna be receiving a little over $1 million. For the higher bond amount, it's $1.6 million. That's paid the first installment at closing, then a year after, and then the year following that. That goes to the industrial authority for their use. If this agreement goes away, that's no longer a factor.
So for 30 years, we would get roughly $72,000 a year. We get it up front, and then if you divide the 30 years into the 2.16, that would be $72,000 a year. I
I've
mean,
not
but-
done that math, so for the lower bond amount, the total amount given is, or paid, is 32.4 million. So.
3.2.
32.4 over the 15 years total,
Okay.
2.16 times 15. So if you divide that out, I don't like to do math in public, that's $1
So we have to do this.
a little over $1 million a year if you paid over the 30 years. So it's a time value of money that was important to the industrial authority. I know not all the members were present when that was negotiated, but just to give some context.
We got some comment from the public, and if you could, stay on the topic. I know there's other topics that's at, but just real, because I don't want to get into 9:30 and then try to rush through the comment.
All right, I'm gonna try and cram this in real quick.
Can you identify yourself, please?
My name's Hal Roach. I thought everybody knew me by now, but so on the tax reassessments, when they go through, the county has to, if it's inflationary and city, roll back that inflationary amount in the millage. So you're not necessarily,
that.
well, there's two areas, and this, you'll see where I'm coming from. There's two areas. If you have to roll back the millage due to inflationary increases, and that's part of state law.
So our millage.
Now, if it's growth, if I go out there and I find
is,
you put a garage on your property, that's growth. You're gonna see a tax increase. So, but if it's inflationary, there's a rollback that has to be considered. So what that means is your millage rate may go down, which means that next era for the portion that they're gonna pay is going to be less. Yes.
I thought it was already.
I'm a tax man. I'm a tax man.
That's why they're doing this.
No, it's already locked in there, right?
No.
Yeah, it's locked in.
Hold on.
I'm talking about the remaining taxes. There's 40% abated, there's 60% still out there.
But have you also thought how, if they don't do
All right,
this-
stop. Let me speak,
Okay,
and then you can
I'll
speak.
rebuttal, yeah.
Okay.
Well, let's
Now-
go point by point. Let's ask questions.
All right, but not, no,
Don't
I'm,
ask the industrial authority to be.
all right, but I'm getting interrupted,
I understand you are.
and I'm not gonna be interrupted.
Well, I can't ask you to leave.
And I know that. So, that's that point of it. But the other thing is back to the vote. Y'all keep saying we voted to approve. You voted to approve based upon completion of the documents. Go back and look at your December meeting. That's what you voted on. Has any member of this board seen the completed documents or reviewed them?
Hold right there. Can you respond to that?
But if you had a complete set of documents that, when the vote occurred, you had a complete set of documents subject to, I don't remember what the minor changes were, and I'd have to go back and look into that. I was there too now.
Yeah.
And, the documents had been, y'all were there, y'all came and had the set, and the attachments and that you're discussing now were part of the documents that were there. I don't recall there being any other modifications. The only thing that was left to do was the execution of the documents and then move forward with the rest of the validation process. That's my recollection.
Yeah, there's a nuance here that I think is important. The bond resolution has to be complete. In the bond resolution, it says that the attached documents, other than the MOU, because the MOU is already executed, those are forms of those agreements, and those we can still negotiate through closing. The limit to that under Georgia law is that we can't change the security of the bond in any of the changes in the documents, but those normally aren't the kind of changes that y'all as a group are concerned about. Those are the interest rate, the not to exceed amount, the maximum debt service payment. Those are very financial terms that can't change. So yes, the forms needed to be attached and were attached in the version, but those forms are still negotiable and won't be executed till closing and are not complete to date, and they shouldn't be.
Okay. How?
Okay, so that was, because there was a long discussion about not having the completed documents, and Scott sat there and he had a set of documents on his desk, and you had said that you even hadn't had a chance to review them.
And never looked at them.
So this is what our whole argument has been this whole time about doing things the right way. How do you vote on something that you don't know what it contains? That's your job, guys, come on. You're right, you represent the taxpayers. We're dependent upon you to make sure that the T's are crossed and the I's are dotted. And that's all we've asked for. We've been pegged anti-solar this, that. The guys, come on.
we've all been pegged something, but,
But-
okay, so is any
you know,
other, is any other?
So there's that right there. But back to the tax assessment stuff. I went through the schedules. I don't have them with me, but it's nowhere near $1 million a year. Nowhere near. And you got to understand that in there, it's divided up. It says in there it's going to be divided up the same as taxes. So that means the city gets nothing because this is a county project. That means the school's going to get so much, and that means the taxpayers are going to get so much. And the portion that the taxpayers is going to get is probably going to be about 35% of the total bill. So that's what they're going to get. And I think it's more along the line of about 300 to $500,000
Hold
a
on
year
right
that
there.
you're going to
All
get.
right, did you have?
To my understanding that this, and I heard what you said too, Chairman, that the city benefits from city and county services.
Through joint.
Right, right. So there is, I mean, even though I live in the city, but I'm a resident of the county also. So there is some benefit in addition to was it the
Not
bike?
direct financials, but it does help the county, and pay taxes to the county as well, so
Yes.
it does.
And I'm gonna interject right here, we're past the 9 o'clock hour, but if anybody needs to go to their job or whatever, I don't foresee bringing up any vote for an industrial authority today, because there's no vote required, to do anything. So, the document that needs to be signed does not have to have a vote by the industrial authority. Okay, Hal?
One last point. When Scott signed that document that day, he knew that it was in contention about completion. And in my view, his signature on that document that day says that I'm going against what the board says, and I'm sending this on through.
Well, we don't know what was in his mind, we can't say
Yeah,
what
so,
he knew or what he
but
didn't.
I'm just saying that. If it's an incomplete document, why did you chairman at the time sign it and send it through?
He might have been listening to attorney thing, we can't
Yeah.
go into.
So that's my point on it, and that's all I have to say.
Suzanne?
Thank y'all for
The
letting me
question
speak.
I have is, was NextEra chosen for the bid? Are they on the short list, and do they have a power purchase agreement? Because this is a question that we cannot seem to get answered.
So given the status of negotiations with customers, I am not able to speak to any specifics about contracts. That's the agreement we have with our current customers. I'm not able to say. And when I am able to say, I will share that.
So as a board, they're basically trying to approve a project that y'all don't even know if you have, or you're not willing to say that you actually have,
It's not that I'm not willing, I'm not able.
which is
The
sleight of
contract's a
hand.
contract. The contract's a contract, Suzanne.
A sleight of hand though.
Well, it does say that, the MOU was that prior to the closing, the company shall update and, not will, but might, but shall, the purchase agreement of any retail electric provider for sale to the company.
Yes, before closing.
So this is not really, I know what you're saying, basically when everybody signs off on it, but everything is done by that point.
Of course, yes. We're not gonna start construction without a commercial contract.
Oh, I'm sorry.
Good morning, everybody. My name is Lee Perry Harper, senior political science pre-law student at Savannah State University here. Originally graduated from Irwin County High School, so I am a former citizen. My question is, it seems to be the concern of the citizens, and it also was brought up, a big concern from the mayor saying he didn't want to run into any legal trouble. Is there a way that there's public, access to like the contracts or the MOU, because that's what kind of seems to be the big misunderstanding, that they're not able to read. So is there any type of documentation that the citizens can access to read so they can get a better understanding for themselves? Because I think that's kind of a bit of the fundamental stages of the confusion from the citizens. So is there something that they can read so they can get a better understanding?
Other than contacting the industrial board members, I don't know why we would, the board as a whole would distribute it to the citizens, but our Ocilla Star has a copy.
Okay.
They hadn't chose to publish it or anything. I don't know, Tony, you might wanna.
I think the documents that we're discussing there are subject to open records requests.
Right.
So a properly, drawn open records request would
Right.
result in a response.
Right, and I
Yes,
think,
yes, ma'am, that-
yes, I think that will kind of help with, and this is me speaking, to the citizens here, that
Good
might
point.
help with a little bit of the
Good point.
confusion, making that open records request to get your own understanding, because it can seem like going back and forth and talking with these people, but maybe going and looking for yourself might bring a little bit of clarity to the situation, because y'all seem to be very concerned. So that was one of my biggest questions, and I definitely, I appreciate the concern of the mayor for having that legal concern as well, to looking into, running into some things. So, yeah, I think that might be the best thing to move forward with as a citizen that's truly concerned.
Thank you, LaPierre, I raised you right.
Anybody else?
I'm Becky Cook. I just have one quick question for Next Era. I did notice when I read through the application that you submitted that there is plans for another set of batteries over on County Road 64, which is Pansy Road and Bethlehem Church Road. Is that actually planned? Because I live over that way and I know exactly where that is. And it's between two substations. So is there another project in the works in that part of the county? Is there another set of batteries going in?
Are you referring to our Amber Solar
Yes.
application?
I am.
So that there was batteries on Pansy Road?
It's County Road 64 and Bethlehem Church Road.
Let's see. That is not part of our Amber Solar project application that we provide to the county.
It's on the application line.
It is.
It's in the application.
It's in there. That's why I'm asking. Because
What's in there?
The actual named site for the batteries, for another set of batteries.
I would like to sit down with you and review those documents. That is not my understanding.
Okay, any questions, particular? I got a question too. I know on the, responsibility on the MOU, the fire protection and specialized equipment really was not a concern before the battery, part was put in after, so to speak, I mean, it was later on in the process. You know, at one time it was 270 million just solar panels. Now we've got battery, that's gonna be in there. And from what I understand of what I've read, and you can help me with this, is that it's gonna take a specialized fire department to be able to address the fire at batteries. And they do catch on fire. I mean, not often, but they do. So who is gonna be responsible for the fire protection?
So I have met with the county's emergency response director. Brandon, thank you. And I've met with the fire chief. We've sat down, we discussed the solar project, we've discussed the battery. Safety is our utmost priority. We've had kind of general conversations with the fire department about what happens in, you know, in out of normal event, and we would want the fire department to be fully equipped to mitigate any kind of thermal event. Generally speaking, the direction for fire departments in situations like these is to maintain a perimeter around the facility, prevent spread of any kind of incident, and just maintain, you know, we prioritize safety, human lives over property.
And that would be a cost to the county, correct?
No.
Oh, so you're gonna provide that?
If there is any additional equipment necessary to ensure the safe operation and emergency response, we will work with the fire department to assess those needs and will assist. I can't guarantee that we.
So you won't work with, you will pay?
We don't believe currently that that the equipment the fire department has is insufficient, but if that changes between now and when we develop the emergency response plan as part of our ability to start construction, that will be reviewed and discussed with the fire department. We do not want them to be underprepared, but we believe, given the fact that they are a well-functioning fire department that's able to contain and put out standard fires. They can contain and prevent the spread of fire, a thermal event, in a battery situation. You know, the design of the project, the battery facility is designed specifically so to prevent spread beyond the facility itself.
But it sounds like Irwin County's gonna be responsible.
May I interject something?
No.
I'm,
Not yet.
okay, sorry.
So, responsible in what respect?
In
Sorry.
pay. Money, I'm always worried about
For-
money.
for the equipment?
For the, well, the equipment, for the maintaining of a fire person on staff that knows how to do that. There'd be some type of special training, I'm sure.
So we
And
would
it, when you say negotiate, is that gonna be before closing and we're gonna put it in the bond resolution, or where does that come in that you're gonna pay?
Before we start construction, we provide a robust emergency response plan that deals with tornadoes, plagues, fires, wildfires, you know, all sorts of emergency situations.
So who pays? That's what I'm
We
asking.
pay for the training. If there, I don't believe additional equipment will be necessary, but if it is, I will commit to providing that.
Chairman, one way we can address this, if you want it to be documented in the documents, is that at closing, we can amend the memorandum of understanding with an economic development agreement and put forth some additional terms that, you know, reflect what's actually gonna happen, but just give y'all some more comfort if that would help.
Well, that would help, but so if we get down to that, and I say, I want a fire chief, you know, a fire patrol, whatever needs, and you say, well, we're not gonna do that. So what recourse do we have? I mean, basically, y'all would have all the cards in your hand, because you've already got a bond resolution with a contract, incontestable. Where would we be able to, you know, where would we be able to have any kind of assurance that that's gonna take place in
Well, if
good
it-
faith?
Well, if it again, if it doesn't affect the security of the bond, we are still open and able to negotiate and do throughout these transactions, no matter who's involved. In all transactions I do, we still negotiate. So they are very much still negotiable terms that we can put into a document. There is no issue with that. And, you know, I've fought down to closing on some issues, and you get closed because both parties want it to be right and want it to be done correctly and benefit both sides. So, I mean, there's some good faith, you know, negotiation that will go on, but I don't want it to seem like we're just gonna, you know, close and not treat y'all right and not do what is correct and ethical and, you know,
Well, I'd like to hear from Tony, and then Mr. Dorsey, I'd like for you just to kind of speak generally, maybe, if you would.
Mark
feel
Darcy is
comfortable.
the attorney in the
Pardon?
TV show. I'm Rob.
I'm sorry, I'm sorry.
Yeah, but Mark Darcy is the attorney in Bridget Jones.
Okay. So, would you have a comment, to kind of circle it all around a little bit, or would you rather not?
Oh, no, you know, there's some clarity, you know, you know, just listening to the conversation. You know, it's like, we have a process that's been voted that's on a track, and in my opinion, it has to advance. You know, what's
In your
considered,
opinion, what?
It has to advance.
Okay.
So the question is, then, I mean, what I don't think is negotiable, for example, would be, you know, if you wanted to come and ask for less, a better treatment, or more tax abatements, the answer to that would be no. Correct? If you wanted to do 30 years instead of 15, the answer to that is no. The core terms, what I call the deal points, are set. The subtle issues that you're talking about relate to the actual, the practical realities of doing the development and that particular interface with this community. Is that a fair statement?
Yeah.
Are there, you know, and I want to, are there, you know, other than, because here's the deal, you know, if you're wrong on your assessment and we don't have adequate fire and, your entire place burns up, you got insurance, that's your problem. You have no recourse against us, and if it gets out and hurts somebody else or their property, you have that liability, not us, okay? So, to the extent that there is you take a chemical plant, to the extent there's a increased risk associated with certain aspects of that, I would expect that y'all would be, it'd be in your best interest to evaluate that and be sure that we were all ready to handle that. And I would expect, to the chairman's point, that that'd be something you want to put money in. That's a different form of insurance policy. But those kinds of terms can be, that kind of nuance can be addressed. But, is there a hope? Because the question I think that maybe the chairman might have was, can we do some more wholesale? Or the chairman of the county commission, where are the boundaries, is what I'm trying to say. Where is the non-negotiable end and where does the potential negotiable begin?
So it actually works for y'all's benefit mostly, and this is a true public finance rule, but if you make the deal worse for the purchaser of the bond, and in a real situation, that's gonna look different than if it's NextEra or in a true financing situation, but we can't do anything to the documents that mean that the deal is worse for the security of the parties involved. So we couldn't lower the amount that y'all are gonna get each year unless there was some offset that raised it and made that equal sum change. Like the terms that benefit the county and the community and the pilot payments, and those things can't get worse for people involved in the deal. They could in theory get worse for NextEra if NextEra was willing to increase any amount or sort of increase its roles and responsibilities, or just paper the roles and responsibilities, because I think the fire one is, we can paper it here, but I think that that's a responsibility that exists sort of outside of the IDA's role, but there's absolutely no problem with papering those things, especially if it brings y'all comfort.
Right, so it can either be part of this, or Carl and I can sit down with Brandon, the fire chief, and come to an agreement, because to Tony's point, it's in NextEra's best interest that everyone is safe and that you are prepared for, an unfortunate circumstance. It's not in our best interest to leave you high and dry. So, Carl, I don't know if you wanna sit down and have that conversation separately, or if we want to wrap it into this at a later date as we negotiate those exhibits, but, we have time to figure this out. I don't want you to feel that by moving forward with this, it means that you're exposed to fire department risk.
Would you kind of give your thoughts maybe on the discussion or not? Either way.
Well, there seem to be a lot of moving parts here that are causing a lot of consternation among the citizens of the county. Seem to be a lot of different opinions on the board, pushing, not pushing, wanting to. I would caution moving forward too fast. I mean, obviously, there's a lot of things that have been reviewed. It doesn't sound like the county audit folks have looked at the financial side of this at all. I know there's one county in South Georgia that the GBI is investigating members of their Economic Development Authority right now because of some solar issues. I'm not gonna name the county right now because GBI is involved, but it looks like there might have even been some personal financial issues involved in their decision-making, which, GBI's got a whole audit team that's very good at forensic auditing for things like that, who owned what property, whose cousin owned it, was there any type of, close connection, those sorts of things. So I would probably at least, the taxing authority should at least take a look and balance out the numbers. I know in one county I work with, it turned out it was a zero-sum game when the dust settled with one deal. County ended up not making much at all on the deal. It may have been bad negotiating on the company's fault, who knows? On the county's fault. It was long before our time got involved. It was like 7 or 8 years ago. But, I would at least do the due diligence to let the county taxing authority, who's responsible for collecting money for the county, at least take a look at it. What's the harm? They're the lawyers are not CPAs.
I got it.
And I am not gonna tell you how much money you're gonna make off this. I've got a math degree and I'm not gonna tell you how much you're gonna make on it. I'm sure the other attorneys in the room at best have math degrees. There might be a CPA in the room as an attorney, but I wouldn't, I'm a chemical engineer, but I would tell you to do chemical engineering because I'm a lawyer now. That's why the CPAs are there. And you have taxing authorities here who are CPAs.
Well, my problem is I don't understand the bond whole process. I have looked at it and I've studied it, I've done my due diligence, and I don't understand it. And that probably is part of the problem of my problem, you know, that I can't understand, because I've never done one. Once I've done this, then I'll understand the process. Tony's been very helpful, NextEra has been helpful. I think though, on my view, I would like to have the NextEra folks, we could do a Zoom. They've never requested, other than, at the last minute, I think, last couple of days, said, could the NextEra attorneys come? And, I said, well, yeah, anybody's welcome, you know, anybody can come. So, but to move on, I have chosen not to sign it. Melvin, if you like to sign it, you can certainly, there it is, and the secretary is right there.
Thank you.
You can choose not to, and maybe me and you and everybody that would wish to, that has other questions, could sit down with NextEra, have some discussion, get our minds clear, and then go from there. I'm kinda like with Tony and the attorney, just what he said, they're just attorneys, they just, you know, they're giving you what is legal. It's not necessarily what's the best interest or not the best interest, so. You live in the community, you've lived in the community all your life, and it's a big decision, to me.
It's major. Walter, if I can add one thing, I would look at this as a board, and I'm not on the board. If I were advising a board in Tony's place, and I'm not, telling Tony how to do his job, I would look at it from a board perspective, two issues: protection of the citizens, and how much revenue. That revenue is gonna have to come from an accounting specialist, and protection of the citizens is your all's job. So, do we have adequate safeguards in place? Do we have adequate protections in our MOU with them? You can't stop the solar from coming in. It's gonna come in eventually. It's just, have we done an adequate job of negotiating protections for the county and the citizens? Do we have adequate setbacks? Are people gonna be having a nuisance to their property? Are they too close to some property owners or others? What's gonna happen to the valuation of property of our citizens? Are we gonna make a little money for the county, but in the long term, devalue some people's property? And I would also make sure that nobody on any of the boards or the commission is making any money off this deal, because that would be bad. Because that would cause you to lose trust in the citizens of the process.
Last word, Tony?
The ordinance, and there's no secret that before it came, we were involved in helping shape the ordinance for the county. And we are having discussions about the ordinance, and I think the ordinance provides really good protection. That could be debatable.
That's the planning ordinance, is that
Yes,
right?
ma'am.
Yes.
So, you know, that level of scrutiny, you know, rests with the county. And right now, you know, prior to the ordinance, there was absolutely no protection, zero. So you went from zero to something, right? You didn't, you know, you can't say that you know, it might not be enough. That would be maybe a point of debate, but I would make that observation presently. And, you know, I'm not a CPA, but I do know how to do math, and, you know, I would really encourage, I think that those that choose to really dig real in the numbers and find that the numbers are meaningful to the community. You know, I'm not being an advocate, I'm just speaking in response to that. You looked at the deal. So, but I'm led from you guys, y'all have a date. Would you please tell us what that is before we go?
Yep, Georgia statute requires the notice to be served on the district attorney within 6 months of the bond resolution being adopted and the signature being authorized. So we did that, y'all did that December 18th, which would put that 6 months at June 17th. So the document has to be signed by then.
You know, through this whole process, and I'm just gonna speak for Walter Hudson, not the industrial board, but I have observed that it's always a rush. I mean, why didn't somebody come up 3 months ago and tell the industrial board, and say, hey, I want about 2 minutes of your time, and let y'all know what they need. Why is that you wait till, you know, okay, it's June? I don't see where the dates are important. If that's y'all's problem, y'all should have come before our industrial authority and informed us that. And then maybe we just put a more rush on. I never heard those dates till you just spoke them.
Well, definitely could have done a better job of letting you know the dates. I think we, you know, y'all had to do your DCA filing, which I think y'all got done in March or April. And since April, I've been in talks with
We cleared the DCA.
Tony and Nick probably, you know, twice a week on that. So, you know.
The only thing I would say is there in the interest then, to the extent you have a date to try to achieve the objectives that the chairman has said about some Zoom or some discussion. So What do y'all?
I'm here, ready, willing, whatever.
So if we don't hit the date, and for whatever reason, just don't do signature, we just don't want to, can they appeal that to the Georgia attorney law and then say, well, we need an extension? Cause I mean, typically, laws are always there, but it seems like you can extend them or do something. Is there a possibility of that?
I think it's dead.
Pardon?
I think the deal's dead if you don't go forward. Tell me what happens.
I think that it would be a violation of what y'all authorized in the bond resolution, and there would have to be some sort of remedy, you know, or potential for some sort of remedy, so I think,
When you say remedy, basically, the attorneys would sue Irwin County or Industrial Authority?
I'm not gonna beholden NextEra to a course of action at this point when it hasn't occurred, but, in order to, you know, because we have relied on, the bond resolution in our actions, a lawsuit would be a possible remedy. There are other remedies available under the law that I would let a litigator discuss, as I'm a
Are there
bond lawyer.
extensions that are possible? I mean, I think that really was a question.
The statute isn't allow for any, there's not specific case law on it. There's one case on the second part of the timeline, which is between the district attorney and filing, which is a 20-day timeline. And that case doesn't dictate anything about the 6 months, but at least helps know that the court took it very seriously, those deadlines. So, you know, it might be a case of first impression if it happens.
What happens if the judge declines to move forward with the bond?
The judge doesn't validate it, that is a process NextEra can appeal. And that is also a process that can be intervened on by anyone that has an interest and is a citizen.
You're not without a voice in
Right.
that process.
Right.
Correct.
Everyone has a voice.
Yes.
Cause that'd be a public meeting.
Yep. Has to be.
I am open. I'm leaving town today and I'll be back next week. And I would be glad for myself and the mayor, not trying to hide anything from the industrial authority, any of the industrial authority people that would like to come or visit or whatever during that time. I'm not gonna call an official meeting because number one, we don't need an industrial authority vote. So, but I do wanna keep everything public. I'll invite Becky and you can film it, whatever you'd like to do. But that way I think we can have a lengthy conversation on why, or maybe you can show me if you've got a copy of the bond resolution.
I can send you anything.
Pardon?
I can send you anything.
Well, I know, but I'm saying the questions I've got didn't transfer from the MOU into the bond resolution. Why? And so we can discuss that. No reason to try to hash it out. I'm not sure, have you got one on you, a bond resolution?
Not with me.
Then we can't discuss it.
I do have it on my phone.
Well,
I
I've
just
got it
don't
on my
print
phone
it.
too, but I always like to look at stuff.
I know, me too.
I'm a little slow.
No, not slow.
So, with all that said, I appreciate y'all's patience. To me, this is the most important decision that Irwin County could make in the next 30 years. Yes.
Sitting here listening to all what's going on. Mr. Mayor, when I took that baton, when you asked me to come in on this after 3 months, I didn't have no idea. I didn't vote for a lot of this stuff because I didn't know. And it's my fault because I took the baton from a former, no, he's not former, but another city councilman, without knowing all this going on. But I'm here to work with you in the kind of way that I can and give you my opinion.
I completely trust your judgment. I've known you all my life, and y'all, you've been family, so I don't have any doubt that you won't make good decisions. And I thank the mayor for appointing somebody as yourself.
Applaud that.
So anyway, we all felt that way. I know Ms. Phillips got a call this week. I wish the people would not call industrial authority people on their private phone about an issue, but I can't. That's just like a sales call. You just hang up on them. Do I hear a
Walter
motion?
add me to the meeting with, part of the meeting.
Never thought I would.
But
I will. I'll put out an email to all the industrial authority boards. I'll get with them, and I don't know anybody's name, but with NextEra and the attorney, and then let's sit down. We'll have a day-long we'll bring our lunch and, whatever, but
And should you, and just to piggyback on what you said, should you be one of those persons who have any of our personal information, please refer them. Most of us probably have a city, a county, or some type of business email, phone number. It just puts you in a bad spot.
Well, Ms. Phillips received a personal telephone call
I
on
did
her
too.
personal phone, and I thought that was very inappropriate. There's nothing else I don't think an attorney can do, because it's basically like a sales call, you know, you just hang up on them, you know, or you can cuss them a little bit.
I report it, so.
Oh, yeah.
So do
You
we
need a
have,
motion?
do we need a motion for dismissal?
I'll make a motion.
Here a second, and all opposed? Okay.
Meeting adjourned.
Have a great
I will
day.
have the